Hello, everyone, and welcome to One Civil Law. And for today's stream, we're going to be discussing the new executive order by Donald Trump, which purports to clarify what birthright citizenship is. So in order to become a citizen of the United States or really any state, you kind of have two options. You're either a citizen when you're born or you become a citizen after you're born. If you become a citizen after you're born, we can call that naturalization. You become naturalized into the country. That's one way to do it. The other way is you become a citizen when you're born. That typically happens one of two ways, either because of where you're born or because of who your parents are. You know, you get your citizenship because of literally the soil or literally your blood. So, you know, blood and soil, lol. So yeah, those are sort of your two options. And most countries use some sort of hybrid between the two. And the United States is no exception here. The United States will give you citizenship because of who your parents are, no matter where you're born in the world, or they'll give you citizenship because of where you're born, namely inside the United States. But the United States has one of the more expansive versions of citizenship because of where you're born, because of the soil. Most countries in the world will not grant you citizenship just because you are born there. Looking at pretty much all of Europe, for example. To the best of my knowledge, no country in the EU has birthright citizenship. Definitely not within the Schengen agreement, which is not necessarily the same thing as the EU, incidentally. Those are different countries. But none of them have birthright citizenship. I remember reading once when there was a whole controversy where Ireland had birthright citizenship for about 5 seconds, and it became a huge thing because of Ireland being part of the agreement would mean that those people born there would be like citizens anywhere. It became a huge thing. Anyways, I digress. So we're going to discuss a little bit about the issue of birthright citizenship inside the United States. And the Constitution of the United States in the 14th Amendment provides that every person born or naturalized in the United States, subject to the jurisdiction thereof, shall be a citizen of the United States and the state in which they reside. And that language, subject to the jurisdiction thereof, is the language that we are going to try to be parsing out a little bit on this issue. What does it mean to be subject to the jurisdiction thereof? What exactly does that mean? That's a good question. So to answer that question, at least in part, we're going to consult the best Supreme Court case there is on this point. And that is the United States versus Wong Kim Arc, a case from 1898. So this is the closest we've got to a case that's on point. So we're going to read this case and try to figure out what it might say about our broader question. Great. So we are in the United States Supreme Court from the Northern District of California, decided 1898, in which the court writes the following. This was a writ of habeas corpus issued October the 2nd, 1895 by the District Court of the United States for the Northern District of California to the Collector of Customs at the Port of San Francisco in behalf of Wong Kim Arc, who alleged that he was a citizen of the United States of more than 21 years of age and was born at San Francisco in 1873 of parents of Chinese descent and subjects of the Emperor of China, but domiciled residents at San Francisco. So they are domiciled, which is to say they are green card. They have a green card. I don't know if we called it a green card in 1873, but that's what they got. Great. And that on his return to the United States on a steamship, Coptic, in August 1895 from a temporary visit to China, he applied to the said Collector of Customs for permission to land and was by the collector refused such permission and was restrained of his liberty by the collector and by the general manager of the steamship company acting on his direction in violation of the Constitution and laws of the United States. So he's being held, hence the writ of habeas corpus. He's being detained. And am I being detained? Yes, you are. So he'd like to not be detained very much. Not by virtue of any judicial order or proceeding, but solely upon the pretense that he was not a citizen of the United States. So the only reason we're holding him, he says, is because he's not a citizen, which, you know, he's trying to come into the United States. He's trying to come in through the border, right? And they're like, no. And he's like, but I'm a citizen. And they're just like, no, because we don't think you are. So that's the whole thing, right? At the hearing, the district attorney of the United States was permitted to intervene in behalf of the United States in opposition to the writ and stated his grounds on the intervening in writing as follows. And so here the United States government writes the following. that as he's informed and believes, the said person in whose behalf said application was made is not entitled to land in the United States or remain therein as is alleged in application or otherwise, because the said Wong Kim Arc, although born in the city and county of San Francisco, state of California, United States of America, is not, under the laws of the state of California and of the United States, a citizen thereof, the mother and father of said Wong Kim Arc being Chinese persons who were subject to the Emperor of China, and said Wong Kim Arc being also a Chinese person and subject to the Emperor of China. So their argument is his parents are Chinese citizens. They might have a green card or whatever the equivalent is in 1873, but they're Chinese citizens. And so he doesn't get to be an American because they're not American. Okay, that's their argument, even though he was born in San Francisco. Economath for $10 says, keyword in the case domicile. Can a legal alien ever establish legally cognizable intent to establish domicile? No. And this case is not going to ultimately answer the question. This case is not going to ultimately answer the question, but it's as close as we've got. So as I sort of stated in the introduction, we're going to read this and try to understand it. And then we're going to try to understand what it's speaking to and try to extend its reasoning. Okay? This case is not going to answer the question. This case answers the question, what if they're green card holders? It doesn't answer the question, what if they're not green card holders? But it's all we've got. So we're going to do the best we can and try to reason. It's going to be fine. Great, moving on. Regina Crawford says, this amendment is so outdated. That is dumb. You could say that about any amendment. Perhaps the Second Amendment, for example. The Second Amendment is so outdated. It was created so long ago and is so abused now. Or any other amendment. The age does not nullify a provision of the Constitution. That's really, really dumb, and you should know better than that. I didn't know constitutional provisions had expiration dates. I didn't know they go bad like milk. That's an interesting concept. They go bad like milk. Okay. What is the expiration date of a constitutional provision, just out of raw curiosity? How long is it? A lot of our constitutional provisions haven't been updated in quite some time. Do we have any constitution left? These are some questions I didn't know I had. Because the said Wong Kim Arc has been at all times, by reason of race, language, color, and dress, a Chinese person, and is now, at least for some time, has been a laborer by occupation. He works with his hands. $10 from says, I'm sick of foreigners disrespecting the American half of my ancestry as slaves by reducing Americanship to a game of Red Rover. First of all, hilarious analogy. Second of all, thank you for the super chat. That's an interesting analogy. I like that one. Okay. So anyways, the man speaks Chinese, he dresses like a Chinese person, and he is a laborer, which, at this period of time, that's what Chinese people are doing in the United States in 1873. That said Wong Kim Arc is not entitled to land in the United States. Remember, he's coming by ship. Or remain therein because he does not belong to any of the privileged classes enumerated in any of the acts of Congress known as the Chinese Exclusion Acts, which would exempt him from the class or classes which are especially excluded from the United States by provisions of the Act. Wherefore, the said United States Attorney asked the judgment and this honorable court be made and entered in accordance with the allegations herein contained, that said Wong Kim Arc be detained on board a said vessel until release as provided by law or otherwise to be returned to the country from whence he came, and that such further order be made as the court may seem proper and legal with the premises. In other words, deport him. The case was submitted to the decision of the court by the following facts agreed upon by the parties. So this is a case of stipulated facts, which, fair enough. Said Wong Kim Arc was born in the year 1873 at number 751 Sacramento Street in the city and county of San Francisco, state of California, United States of America, and that his mother and father were persons of Chinese descent and subjects of the Emperor of China, and that said Wong Kim Arc is and was a laborer. That at the time of his birth, His mother and father were domiciled residents of the United States, and has established and enjoyed a permanent domicile and residence therein at the city and county of San Francisco. That said mother and father of said Wong Kim Arc continue to reside and remain in the United States until the year 1890 when they departed for China. So at some point, they went back to China, but they went because they wanted to. So at some point, they're like, we're going back to China. That during all the time of their said residence in the United States as domiciled therein, the said mother and father of Wong Kim Arc were engaged in the production and the prosecution of business and were never engaged in any diplomatic or official capacity under the Emperor of China. They're not diplomats. That ever since the birth of Wong Kim Arc, at the time and place herefore stated in the stipulated, he had but one residence, to wit, the residence in the state of California in the United States of America, and then never changed or lost said residence or gained or acquired another residence, and there reside claiming to be a citizen of the United States. He's lived at the same address all his life. The year 1890 said Wong Kim Arc departed for China upon a temporary visit with the intention to return, and did return thereto on July the 26th, 1890 on the steamship Gallic, and was permitted to enter the United States by the collector of customs upon the sole ground that he was native-born citizen of the United States. That after said return, the said Wong Kim Arc remained in the United States, claiming to be a citizen thereof, until the year 1894, when he again departed for China upon temporary visit with the intention to return to the United States. It did return thereto in the month of August 1895 and applied to the collector of customs to be permitted to land, and such application was denied upon the sole grounds that he was not a citizen of the United States. That said Wong Kim Arc has not, either by himself or his parents, acting for him, ever renounced his allegiance to the United States, and he's never done or committed any act or thing to be excluded therefrom. The court ordered Wong Kim Arc to be discharged upon the ground he was a citizen of the United States. The United States appealed to this court, and the appellee was permitted bail pending appeal. So he was born here. He lived literally at the same address all his life. On one prior occasion, he left the United States for China to visit. He came back. Customs let him in the door. On a second occasion, he left to visit China. He came back. And Customs is like, no, not so much for you, no. And he's like, but I'm a citizen, though. And so that's the fight. Mads gives 5 gift memberships. Squirty Belly, David Reese says, Bulgaria has birthright citizenship as long as the child doesn't immediately acquire citizenship of another country. Bulgaria is in the EU and Schengen. Cool. Neat. Didn't know that. Well, you learn something new every day. I learned fun facts about Bulgaria. Neat. War Hippie gives 20 gift memberships. Great. Let's read what the reasoning of the case is. Mr. Justice Gray delivers the opinion of the court. The facts of the case as agreed by the party are followed. Now we're going to go through the facts again. Wong Kim Arc was born in 1873 in the city of San Francisco in the state of California and United States of America, and he was and is a laborer. His father and mother were persons of Chinese descent and subjects of the Emperor of China. They were at the time of his birth domiciled residents of the United States, having previously established and still enjoying a permanent domicile and residence therein in San Francisco. They continued to reside and remain in the United States until 1890, where they departed for the United States or departed for China. And during all that time of their residence in the United States, they were engaged in business and were never employed in any diplomatic or official capacity under the Emperor of China. Wong Kim Arc, ever since his birth, has but one residence, to wit, in California, within the United States, and there resided, claiming to be a citizen of the United States, and has never lost or changed that residence or gained or acquired another residence. And neither he nor his parents acting for him ever renounced his allegiance to the United States, or did or committed any act or thing to exclude him therefrom. In 1890, when he must have been about 17 years of age, he departed for China on a temporary visit and with intention to return. And he did return thereto by sea in the same year, and was permitted to return upon the sole ground he was native born. So in 1890, he left, he came back, and customs let him in the door. After that return, he remained in the United States, claiming to be a citizen thereof, until 1894, when he, being about 21 years of age, but whether a little above or a little under that age, it does not appear. He's 21-ish. He's 21-ish. again departed for China on a temporary visit and with intention of return to the United States, and did return thereto by sea in August 1895, and applied to the collector of customs for permission to land, and was denied the permission upon the sole ground he was not a citizen. Customs would not let him in the door. It's conceded that if he's a citizen of the United States, the acts of Congress known as the Chinese Exclusion Acts, prohibiting persons of the Chinese race, and especially Chinese laborers, from coming into the United States, do not and cannot apply to him. So the United States at this time has rules, as it does now, at least on paper. At least on paper, the America still has rules about who can come into the United States and who doesn't. But even in 1895, they had rules about who could come into the United States and who couldn't. And in 1895, the United States was like, we don't really like people from China. We don't want them to come visit our country. Which, okay, that's the rule in 1895. We don't like the people of China. But of course, if he's an American citizen, he's not a person of China. Now, is he? So that sort of begs the question whether or not he's a person of China. The question presented in this record is whether, the question, 499 Squirrely David Reese says, my wife is from Bulgaria and our daughter has dual citizenship. That's also very cool. That's very cool. Thank you, Squirty. That's actually kind of sweet in some way. I'm not sure why, but it strikes me as sweet. The question presented by the record is whether a child born in the United States of parents of Chinese descent, who at the time of birth are subjects of the Emperor of China, but, and this is where things are going to depart, from what we're trying to decide today, but this is, again, the closest thing we have. So we're going to go from here and try to figure out what it means for the other thing, okay? So in this case, his parents have permanent domicile, all right? So that's the distinction. They are the equivalent of a green card, whatever that is in 1873. But whatever that is in 1873, they're basically the equivalent of a green card, okay? They have permanent domicile. In residence of the United States and thereon carrying on business and not under the employ of any diplomatic or official capacity under the Emperor of China, because at the time of his birth as a citizen of the United States, he becomes at time a citizen of the United States by virtue of the first clause of the 14th Amendment, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state where they reside. So at least with respect to parents who do have a permanent domicile, they get birthright citizenship. So children of green card holders get birthright citizenship. What about the non-green card holders? I don't know. Let's read more and see if we can figure out what we think. Let's think with our brains, right? Let's think with our brains. Let's read this and try to figure out what it says and what the law is, and try to use our mind muscle and try to figure out what is the answer. If we know what the answer is for people who are green cards, what about the non-green cards? And in order to answer that question, we're going to read the logic of the decision and see how it applies, right? We're going to see what happens if we take away that piece of the puzzle. What can we tease out from this case in order to learn what happens for the non-green card holders? All right, great. Let's do that. In construing any act of legislation, whether a statute enacted by the legislature or a constitution established by the people as the supreme law of the land, regard is to be had not only to the parties of the act, all parts of the act itself, and any former act of the same lawmaking power on which the question is an amendment, but also to the condition and the history of the laws previously existing and the land in which the new act must be read and interpreted. We just told you how to interpret law, right? I mean, this is as true today in 1870 as in 1898. So this is true, right? So in interpreting it, we not only look to all parts of the act itself, which is to say the text, but we also look to the history of the law and how it came to be. So we look to history to try to figure out what they're talking about. That remains true today, along with other elements. History, precedent, purpose, etc., and so forth. So that remains true today. The Constitution of the United States, as originally adopted, uses the words citizen of the United States and natural-born citizen of the United States. By the original Constitution, every representative in Congress is required to have been 7 years a citizen of the United States, and every senator to have been 9 years a citizen of the United States. And no person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible for office of the President. The 14th Article of Amendment, a little formalized language there, besides declaring that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state in which they reside, also declares that no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. This is 1890, right? I think this is pre-Slaughterhouse, because I don't think Slaughterhouse happened for a couple more years. I think it was Slaughterhouse was later, 1890. So the privileges or immunities clause might still exist at this time in history. Anyways, pressing on. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor to deny any person within its jurisdiction equal protection laws. And the 15th Article of Amendment declares that the right of citizens to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. The Constitution nowhere defines the meaning of these words, either by way of inclusion or of exclusion. So it doesn't tell you what is in that list, nor does it tell you what's not in the list. Because you could define a thing by saying what's in there, and you could also define it by saying what's not in there, right? Like, what is my definition of a bird? Not an octopus. That's a definition of a bird, right? It's like, well, that's one way of defining it. In this, and like other respects, it must be interpreted in the light of the common law, the principles of history which were familiar known to the history. So basically, how did the Constitution is itself comes from somewhere. And we've talked about this, for example, in the First Amendment context. We've talked about this in the Second Amendment context when we talk about the right to keep and bear arms, or we talk about the freedom of speech. Right? What do we mean by that? We mean not, what is the freedom of speech? The freedom of speech is not the same thing as speech. It's a bit different concept, right? We have to go into history to understand exactly what they're talking about. What is the right to keep and bear arms? The right to keep and bear arms is not a right to keep and bear arms. It's the right to keep and bear arms. It has a specific definition, and we can move on, right? In order to understand what that definition is, history is our guide. History and tradition, what the hell were they talking about when they wrote this thing, right? What the hell were they talking about? We understand this concept. It's not like foreign to us. This makes sense to us. The language of the Constitution, as it's well been said, cannot be understood without reference to the common law. Yeah, a lot of the Constitution was common law, and then we're like, we like it so much, we're going to make it our Constitution. Yoink, that's our Constitution now. Fantastic. In Minor versus Hapstead, Chief Justice Waite, when construing on behalf of the court the very provision of the 14th Amendment now in question, said, the Constitution does not, in words, say who shall be natural-born citizens. Resort must be held elsewhere to do that. So the Constitution doesn't define it, so we're going to have to figure out some other way. Like, what is the right to keep and bear arms? Well, the Constitution doesn't tell us, so we have to figure it out some other way. What is the freedom of speech? The Constitution doesn't say, so we have to figure it out some other way. My kingdom for definitions, but not so much when it comes to the Constitution. And he proceeded to resort that the common law was an aid in the construction of the provision. Makes sense. In Smith versus Alabama, Mr. Justice Matthews delivered the judgment of the court, said there is no common law of the United States in the sense of a national customary law distinct from the common law of England as adopted by the several states, each for itself, applied as a local law, and subject to such alienation as may be provided by our own statutes. You can change the common law by statute to the extent it's not in the Constitution. But in the absence of a statute, the common law remains. The common law remains in the absence of statute. There is, however, one clear exception to the statement that there is no national common law. The interpretation of the Constitution of the United States is necessarily influenced by the fact that its provisions are framed in the language of English common law and to be read in light of its history. So there is no really like the common law. The common law is more of a concept that applies to state level law, right? There's not really any federal common law, or at least not much of one, right? There is maybe a smattering of little concepts that might be thought of as federal common law, maybe, but you'll often see this kind of language from the Supreme Court. They're like, there is no federal common law. You'll even see it in modern decisions. It's like, do they literally mean there's no federal common law? Well, if not none, pretty close to none, right? Common law is more of a state level concept. The federal Constitution doesn't really, the federal doesn't really do common law. This is principally because the Constitution itself creates the federal government, right? The states pre-existed. The states created the federal government. The federal government didn't have an antecedent. It was created out of nothing. So it has no antecedent except for the states creating it. And so, well, they created it using background principles, though. So it doesn't have common law except in so much as the Constitution itself adopts the common law. So there's no common law outside the Constitution. Maybe that's one way of putting it. It's a very sort of geeky. It's very geeky, technical there, and like technically correct. There is no common law, but pressing on because it's a very fine distinction and it's not important. The fundamental principle of the common law with regard to English nationality. So now we're going to decide, well, how did the English determine who is a citizen? That's a pretty good, right? That's a pretty good place. How did the English determine if someone was a citizen? All right. The fundamental principle of the common law with regard to English nationality was birth within the allegiance, also called I don't know how to pronounce this word. It looks like legality, but I don't think that's how it's pronounced. Obedience, faith, or power of the king. The principle embraced all persons born within the king's allegiance and subject to protection. The principle, such allegiance and protection were mutual, as expressed in the maxim protecto trahit subjectum ex subjecto protectum, and were not restricted to natural-born subjects and naturalized subjects, or those who had not taken an oath of allegiance, but were predictable of aliens and enmity, so long as they were within the kingdom. Okay. So basically, everyone born within the king's allegiance is subject to his protection. Legality. Yeah, okay, legality. Okay, that's cool. Children born in England of such aliens were therefore natural-born subjects. But children born within the realm of foreign ambassadors or children of alien enemies, born during and within their hostile occupation of part of the king's dominion, were not natural-born subjects because they were not born within the allegiance, the obedience, or the power, as would be said this day, within the jurisdiction of the king. So an alien is simply anyone who's not a citizen. And this fundamental principle with qualifications or explanation of was thought clearly, though quaintly stated in leading cases known as Calvin case or the case of Postani, decided in 1608 after a hearing in the Exchequer Chamber before Lord Chancellor and all the judges of England, and reported by Lord Coke, Hala, and Lord Ellesmere. The English authorities ever since are of like effect, citing Lord Hale, Lord Kenyon, Cockburn on nationality. In Undy versus Undy, 1869, I'm assuming that's a citation to an international court of some kind. What the hell is LR1LHSC 441? What the heck kind of citation is that, man? I don't know. The point was decided, it was one of inheritance, decided upon the question of whether the domicile of the father was in England or Scotland, he being in either alternative a British subject. Yeah, I mean, right. People born in England or Scotland are British. I understood that. Lord Chancellor Hathaway said, the question of naturalization and of allegiance is distinct from that of domicile. Lord Westbury, in passage relied on by counsel for the United States, began by saying, the law of England and of almost all civilized countries ascribes to each individual at birth two distinct legal states or conditions, one by virtue of when he becomes subject of some particular country, binding him by the tie of national allegiance, and which may be called his political status, another by virtue of which becomes ascribed to him by character of a citizen of some particular country, and as such is possessed of certain municipal rights and subject to certain obligations, which latter character is the civil status or conditions of the individual and may be quite different from his political status. And then, while maintaining the civil status, is universally governed by a single principle of domicile, domicilium, the criterion established by international law for the purpose of determining civil status, and the basis on which the personal rights of the party, that is to say, the law which determines his majority or minority, in other words, is he an adult, his marriage, succession, testacy, or intestacy must depend. Yet, distinctly recognize that a man's political status, his country, partira, and his nationality may depend on different laws in different countries. He evidently used the word citizens, not as equivalent to subject, but rather inhabitants, and no thought of impeaching the established rule that all persons born under British dominion are natural-born subjects. Which language sounds a lot more like illegal aliens would qualify in that kind of language, to be honest. Lord Chief Justice Cockburn, in that same year, reviewing the whole matter, said, by common law of England, every person born within the dominion of the crown, no matter whether of English or of foreign parents, and in the latter case, whether the parents were settled or merely temporarily sojourning. Uh-oh. Yeah, this is going to be a real problem for the U.S.'s idea of let's terminate birthright citizenship. This language is pretty on point. This is a problem. This is a problem for ending birthright citizenship right here. By the common law of England, every person born within the dominion of the crown, no matter whether of English or foreign parents, and in the latter case, which is to say foreign, whether the parents were settled or merely temporarily sojourning in the country, was an English subject, save only children of foreign ambassadors who were exempted because their fathers carried their own nationality with them, or a child born to a foreigner during a hostile occupation of any part of the territories of England. No effect appears to have been given to descent as a source of nationality, which is to say, your bloodline. So at least in the English common law, it's all just solely. It's just solely. It's soil. It's soil. It's not England. Yes, but as we've been discussing for like some period of time, do I have to really go through all this again? Or were you not paying attention? Yeah, I understand we're not England, but the Constitution, when it says certain things, is getting this language from certain principles. And how do we determine where these principles come from? Is by common law. It's like, what does it mean? It's by like looking at the common law. And so, yeah. Right. You weren't here? No problem. Texas is England. Its common law is English. Yeah. LR is law reports. HL is the court. SC is the type of law, in this case, Scottish appeals. Well, thank you for that breakdown of some citations. Yeah, thanks for that breakdown of citation. Do they distinguish between legal and illegal immigrants? No. Although, I don't even know if they have the concept of an illegal immigrant at this time in history. I don't even know if that's a concept in the English common law. I honest to God don't even know if they have the concept of an illegal immigrant. Yeah, I don't even know if that's a thing. Yeah. That's why it's different then versus now. Maybe we're trying to understand how it can extend or not. We're trying to understand, but this language is problematic. This language is very problematic for people who want to interpret the 14th Amendment as excluding the children of illegal immigrants. Didn't Trump just make illegal entry a form of hostile activity? I don't know that you can just do that. Yeah, I don't know that you can declare it to be. Yeah, I don't know if you can do that. I guess we're going to find out, but this is, yeah. The writers of the 14th Amendment said that it doesn't apply to illegals? When? Where did they say that? I'm not aware of anything where they said that it doesn't apply to illegals. The writer of the 14th Amendment said that? When did he say that? In what document? Isn't anyone on U.S. soil subject to the jurisdiction of the United States? I would think so. Yeah, did they even have a concept of illegal immigration in 1780? I don't know. Let's see. Let me read more. Mr. Dicey, in his careful and thoughtful digest of the laws of England, with reference to conflict of law, published in 1896, stated the following proposition. His principal rules being published below in italics. Thank you for $9.99, Ms. McGuff Doe. Is your occupation hostile if your occupation itself violates our laws? Within the meaning of this, I don't think so. I think hostile I don't know that qualifies as a hostile occupation within the meaning of that, but it's an interesting idea. It's like, can you understand hostile to simply mean hostile to our laws? I don't know. Interesting idea, though. Good question. British subject means any person who owns permanent allegiance to the crown. Permanent allegiance is used to distinguish the allegiance of a British subject from the allegiance of an alien who, because he's within the British Dominion, owes temporary allegiance to the crown. Natural-born British subject means a British subject who became a British subject at the moment of his birth. Subject to exceptions hereinafter mentioned, any person who, whatever the nationality of his parents, is born within the British Dominion is natural-born British subject. The rule contains the leading principle of English law on the subject of British nationality. The exceptions afterward mentioned by Mr. Dicey are only these two. Any person whose father being alien enemy present can declare an invasion under 50 U.S.C. 21. Doesn't require foreign invasion to be by the military. Okay, let's read what it says. $50 U.S.C. All right, 50 U.S.C. 21 says the following. I put it on screen, but I have to redo my margins in order to put it on the screen. So I'll just read it. Whenever there's a declared war between the United States and any foreign nation or government, or any invasion or predatory incursion is perpetrated, attempted, or threatened against the territory of the United States by any foreign nation or government, and the President makes public proclamation of the events, all native citizens, denizens, or subjects of the hostile nation or government being between the age of 14 upwards, who shall be within the United States and not actually naturalized, shall be liable to be apprehended, restrained, secured, and removed as enemies. The President is authorized to act by proclamation or a public act to direct the conduct to be so observed towards the alien who becomes liable, the manner and degree of restraint to which they appear, blah, 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 blah. So, but the problem is, in order for the President to do this, it has to be either a declared war or an invasion or predatory incursion by a foreign nation or government. And so I don't think that applies to the case of illegal immigrants. Because unless you can show the foreign nation is directing it, then I don't think you can say it's being done by the foreign nation or government. So I'm not sure this provision applies, but it's an interesting idea. So we'll read some more. Thank you for your super chat. Why not? Because of the language I just read. Yeah, because of the language I just read. I'm trying to provide a legal interpretation. So you'll have to ask a more specific question. Any person whose father being an alien at the time of such person birth, an ambassador or other diplomatic agent accredited to the crown by the sovereign of the foreign state is, though born within the British dominion, an alien. And he adds, the exceptional and unimportant instances in which birth within the British dominions do not of itself confer British nationality are due to the fact that though at common law, nationality or allegiance in substance depend on the place of person's birth, it's in theory at least dependent not upon the locality of man's birth, but upon being born within the jurisdiction and allegiance of the King of England. And while it might occasionally happen that a person born within the dominions without being born within the allegiance or other words under protection of the crown, it thus clearly applies by law of England for the last 3 centuries, beginning before the settlement of this country and continuing to the present day. Aliens, while residing in dominions possessed by the Crown of England, were within the allegiance, the obedience, the faith or loyalty, the protection and power of the jurisdiction of the English sovereign, and therefore every child in England of an alien parents was natural born subject, unless the child of an ambassador or other diplomatic agent of a foreign state, or of an alien enemy in hostile occupation of the place where the child was born. Oh, Lord. The same rules in force. Don't worry about what they do or do not do with respect to the Second Amendment. We want to give it its proper interpretation. Right? I mean, like, don't worry about what the administration does or does not do with respect to the proper enforcement of any constitutional provision. We need to figure out what the proper constitutional provisions are. So, like, what any administration has done with respect to any amendment is not really our concern. We're trying to figure out what the language really means. Committing a crime be considered a hostile act? I think by hostile act, my first thought is hostile act I would interpret as an act of war. Would be what I would understand to be hostile act within the meaning of that provision. So I would say no. A routine crime is not a hostile act within the meaning of that, would be my first thought. Do we go back to the original intent or submit to later corrupt divisions from this original intent? Original intent. Always go back to the original. In the early case of the charming Betsy, it appears to have been assumed by the court that all persons born in the United States were citizens of the United States. Chief Justice Marshall saying, whether a person born within the United States or becoming a citizen according to established laws of this country can divest himself absolutely of that character otherwise than in such a manner as may be prescribed by law is a question which is not necessarily present to decide. In Ingus versus Sailors Snug Harbor, in which the plaintiff was born in the city of New York about the time of the Declaration of Independence, the justices of this court, while differing in opinion on other points, all agreed that the law of England as the citizenship by birth was the law of the English colonies in America. Mr. Justice Thompson, speaking for the majority of the court, said, it is universally admitted both in the English courts and those of our own country that all persons born within the colonies of North America, while subject to the crown of Great Britain, were natural born. Yes. Mr. Justice Johnson said he was entitled to inherit as a citizen born of the state of New York. Mr. Justice Story stated the reasons upon this point more at large, referring to Calvin's case, Blackstone's commentary, and Doe versus Jones, above cited in saying, allegiance is nothing more than the tie or duty of obedience of a subject to the sovereign under whose protection he is. And allegiance by birth is that which arises from being born within dominions and under the protection of a particular sovereign. Two things usually concur to create citizenship. First, birth locally within the dominion of the sovereign. And secondly, birth within the protection and obedience, or in other words, within the legions of the sovereigns. Legions. As opposed to allegiance. Legions. This might be my new favorite word, or it's my favorite word of the day. That is, the party must be born within the place of the sovereign is at time, in full possession and exercise of his power, and the party must also be at its birth, derive protection from, and consequently own obedience or allegiance to the sovereign as such de facto. There are some exceptions which are founded upon peculiar reasons, and which indeed illustrate and confirm the general doctrine. Thus, a person who is born on the ocean is subject to the prince to whom his parents then own allegiance, for he is still deemed under the protection of the sovereign and born in a place where he has dominion in common with all other sovereigns. So children of ambassadors are held to be subjects of the prince for whom he represents, although born under actual protection and in dominions of a foreign prince. The children of enemies, born in a place which the dominions of another sovereign, then occupied by conquest, are still aliens. Nothing is better settled at common law than the doctrine that children, even of aliens, born in a country, while their parents reside there, are under the protection of the government and owing a temporary allegiance thereto, are subject to him by birth. In Shanks versus DuPont, decided as appears by the records of this court on the same day as the last case, it was held that a woman born in South Carolina before the Declaration of Independence, married to an English officer in Charleston during the occupation by the British forces in the Revolutionary War, and accompanying her husband on his return to England and remaining there until her death, was a British subject within the meaning of the Treaty of Peace of 1783, so the title in her land in South Carolina by descent cast before the treaty was protected thereby. That's interesting. She is born in South Carolina. She marries an English officer, goes back to England, and so she's a British subject. That's interesting. I like that. Love is complicated even in the Revolutionary War. It was of such case that Justice Story, delivering the opinion of the court, said, the incapacities of femme covert provided by common law apply to their civil rights and are there for their protection and interest, but they do not reach political rights nor prevent them from acquiring or losing their national character. Those political rights do not stand upon the mere doctrines of municipal law applicable to ordinary transactions, but stand upon more general principles of law by nations. The last sentence was relied on by a council of the United States as showing the question of whether a person is a citizen of a particular country is to be determined not by the law of that country, but by the principles of international law. Ooh, exciting. International law enters the equation. But Mr. Justice Story certainly did not mean to suggest that independent of treaty, there was any principle of international law which could defeat the operation of the established rule of citizenship by birth within the United States. For he referred to the contemporaneous opinion of Angus versus Sailor Snug Harbor, above cited, in which this rule has been distinctly recognized, in which he said each government had a right to decide for itself who shall be admitted or deemed citizens. And in the treaties of conflicts of law published 1834, he said that in respect to residents in different countries or sovereigns, there are certainly principles which have been generally recognized by tribunals administering public law as unquestionable authority, and stated as to the first of these principles, persons born in the United States, persons born in a country are generally deemed citizens and subject of that country. The English statute of 11 and 12 Will 3rd, 1700, entitled An Act to Enable His Majesty's natural born subjects to inherit the estate of their ancestors, either lineal or collateral, notwithstanding their father or mother were aliens, enacted that all and every person born, all and every person or persons, being the king's natural born subjects, within any of the king's realms or dominion might and should thereafter lawfully inherit and make their titles by descent to any lands from any of their ancestors, lineal or collateral, which incidentally means by birth or by marriage. Although the father and mother or other ancestor of such person or persons by, from, and whom, and under whom titles should be made or derived, has been or should be born out of the king's allegiance and out of his majesty's realms and dominions as fully and effectually as if such parents or ancestors had been naturalized or natural born subjects or subjects within the king dominion. It may be observed that throughout the statute, persons born within the realm, although children of alien parents, were called natural born subjects. So persons born within the realm, although their children are alien, were considered natural born. Okay. As the statute includes persons born within any of the king's realms or dominions, it is of course extended to the colonies, and not having been repealed in Maryland, it was enforced there. I just love the game of legal telephone that we sometimes play. It amuses me. I love the game of legal telephone we sometimes play, right? Because there's some act that the king passed and now it's common law and Maryland didn't repeal it and now it's a thing and now it's part of the U.S. Constitution and then it gets cited and you gotta love that thing, man. You gotta love how things influence each other. It's part of the fun. It's part of the fun here in law. In McCreary versus Somerville, 9 Wheat 354. Okay, we're still using old school designations for Supreme Court opinions. Really early Supreme Court opinions were named after the editor of the volume. So like in modern opinions, you'll see like 9 US. Well, I don't know if it would literally be 9 US. I don't know. It's 9 of Wheat. I don't know what that is in terms of the US code or the US report. But really old opinions, you'll see like the name of the editor. So it's just funny. Which concerned the title to the land of the states of Maryland. It was assumed that children born in the state of an alien who was still living, see title, there you go, 13 US. There you go, right? So that'd be 13 US as opposed to 9 Wheat. Oh man. We're natural born citizens of the United States, and without assumption, that case would not have presented the question to decided by the court, which is stated by Justice Story in delivering the opinion was whether the statute applies to the case of a living alien ancestor so as to create by title and heirship where none would be existent by common law if the ancestor were natural born subject. Again, in Levy versus McCarty, 9 Pet 102, which concerned a descent cast since the American Revolution in the state of New York, where the statute of 11 and 12 William III had been repealed. This court, speaking by Justice Story, held that the case must rest for decision exclusively upon the principle of common law and treated as unquestionable that the law of a child born in England of alien parents was a natural born subject. Quoting the statement of Lord Coke in Something Lit, that if an alien cometh into England and hath issue 2 sons, these 2 sons are indigenous, subjects born because they're born within the realm. And saying that such a child was native born subject according to the principles of common law, stated this court in McCreary versus Somerville. In Dred Scott, Lord, Mr. Justice Curtis stated, the first section of the second article of the Constitution used the language natural born citizen. It thus assumes citizenship may be acquired by birth. Undoubtedly, this language of the Constitution was used in reference to the principle of public law, well understood in this country at the time of the adoption of the Constitution, which referred citizenship to the place of birth. And to this extent, no different opinion was expressed or intimated by any other judge. In United States versus Rhodes, Mr. Justice Swain, sitting in the circuit court, said, all persons born in the allegiance of the king are natural born subjects, and all persons born in the allegiance of the United States are natural born citizens. Birth and allegiance go together. Such is the rule of the common law, and is the common law of this country as well as England. We find no warrant for the opinion that this great principle of common law has ever been changed in the United States. It has always been here with the same vigor and subject only to the same exceptions since before the Revolution. 1 Abbott The United States Judicial Court of Massachusetts, the Supreme Judicial Court of Massachusetts, speaking by Mr. Justice after Mr. Chief Justice Sewall, early held that determination of the question of whether a man was a citizen or alien was to be governed altogether by the principle of common law, and that it was established with a few exceptions that a man born within the jurisdiction of common law is a citizen of the country wherein he is born. By circumstances of his birth, he is subject to duty and allegiance, which he claimed and enforced by sovereign of his native land, and becomes reciprocal, either entitled to the protection of that sovereign and other rights and advantages which are included in the term citizenship. And again, the doctrine of the common law is that every man born within its jurisdiction is subject to the sovereign of the country from where he's born, and allegiance is not personal to the sovereign in the extent that's been contended for. It is due to him in his political capacity of the sovereign of the territory where the person allowing allegiance was born. It may be observed that in recent English law case, Lord Coleridge expressed the opinion that the Queen's Bench division, that statutes of whatever, clearly recognized the king and his politique, and not his personal capacity, is the allegiance of the subject due. It's interesting that they even tried to distinguish between the two. The king in his professional versus personal capacity. And it's interesting they tried to distinguish between the two in 1806, but okay. I guess it makes some sense in 1806. It's just kind of weird. The Supreme Court of North Carolina, speaking by Mr. Justice Gaston, said, before a revolution, all free persons born within the dominion of the King of Great Britain, whatever their color or complexion, were native-born British subjects. Those born out of allegiance were aliens. Upon the revolution, no other change took place in the law of North Carolina that was consequent upon the transition from a colony dependent on a European king to a free and sovereign state. British subjects in North Carolina became North Carolina freemen, and all free persons born within the state are born citizens of the state. The term citizens, and understood in our law, is precisely analogous to the term subject in the common law. Interesting. And the change of phrase has been entirely resulted from the change of government. The sovereignty has been transferred from one man to the collective body of the people. And he is who before was a subject to the king is now a citizen of the state. That all children born within the dominion of the United States of foreign parents, again, like this language is kind of like pretty broad. That all children born within the dominion of the United States of foreign parents holding no diplomatic office became citizens at the time of birth does not appear to have been contested or doubted until more than 50 years after the adoption of our Constitution, when the matter was elaborately argued in the Court of Chancery of New York and decided upon full consideration by Vice Chancellor Sanford in favor of citizenship. The Court of Chancery is what we would now call the Court of Equity, which we wouldn't call the Court of Equity at all, because in every state except Delaware, to the best of my knowledge, they're no longer distinct concepts. The equity courts have been merged in with the legal courts, and so there's really no distinction. And thank God for that, by the way. Thank God for that. Because that didn't used to be true, like even in the late 20th century, that didn't used to be true. And having two separate sets of courts, it's fucking bullshit. So the fact that we merged the courts, oh my God, made our lives so much easier. So if subject equals citizen, then citizen of the jurisdiction thereof. No. But I do appreciate your super chat. You got me to smile. You're a good egg, Economath. You're a good egg. You funny. You funny. The same doctrine was repeatedly affirmed in the executive department as instanced by Mr. Marcy, Secretary of State, by Attorney General Black, and by Attorney General Bates. Chancellor Kent, in his commentary, speaking of general division of the inhabitants of every country, under the comprehensive title of Aliens and Natives, stated, natives are all persons born within the jurisdiction and allegiance of the United States. This is the rule of common law, without any regard or reference to political condition or allegiance of their parents, with the exception of children of ambassadors, who are in theory born within the allegiance of the foreign power they represent. To create allegiance by birth, the party must be born not only within the territory, but with the allegiance of the government. If a portion of the country be taken and held by conquest in war, which it's a little bit hard to say that's what illegal immigrants are doing with all due respect, then the conqueror acquires the rights of the conquered as to dominion and government, and children born in armies of the state while abroad and occupying are deemed to be born in the allegiance of the sovereign to whom the army belongs. It is equally the doctrine of the English common law that during such hostile occupation of a territory, and their parents being adherents to the enemy are subjects de facto, their children born under such temporary dominion are not born under the allegiance of the conquered. Well, I mean, that kind of is true. I mean, the foreign soldier doesn't have allegiance to the country they're conquering. That'd be really weird if they did. That'd be a really weird concept if they did. And he elsewhere said, if at common law, all human beings born within the allegiance of the king and under the king's obedience were natural born subjects and not aliens, I do not perceive why this doctrine should not apply to these United States in all cases when there's no express constitutional or statutory declaration to the contrary. Subjects and citizens are, in a degree, convertible terms as applied to natives. And though the term citizen seems to be appropriate for a public freeman, yet we are equally within the inhabitants of all countries subjects, for we're equally bound by allegiance and subjugation to the government and law of the land. Well, that's exciting information. I did not know. Apparently, we're all subjects too. I didn't know I was a subject. I thought I was a citizen, but apparently I'm also a subject. Exciting. Exciting. I'm thrilled to learn this exciting and fun information. At least that's what that guy thought. Mr. Binney, in the second edition of the paper of Alienage of the United States, printed in pamphlet in Philadelphia with a preface bearing a signature, said the common law principle of allegiance was the law of all states at the time of the Revolution and the adoption of the Constitution. And by that principle, the citizens of the United States are, with the exceptions before mentioned, namely foreign-born children of citizens under statutes to be presently referred to, such only as either born or made so, born within the limits and under the jurisdiction of the United States, or naturalized by authority of law, either in one of the states before the Constitution or since that time, by virtue of the acts of Congress of the United States. The right of citizenship never descends, in a legal sense, either by common law or under the Common Naturalization Act. It is instant to birth in the country as personally given by the statute. The children of an alien, if born in this country, is much a citizen as the natural born child of the citizen, and by operation of the same principle. The paper, without Mr. Binney's name and with the note in a less complete form and not containing the passage last cited, was published in the American Law Register. It is contended by one learned counsel for the United States, the rule of Roman law. Ooh, we're going way back. We're going way back, people. We're going all the way back to Rome. Make Rome great again. All right, let's go. Has anyone thought about putting like leaves in the president's hair? You know, that could be good. It was contended by one learned counsel for the United States that the rule of Roman law, by which the citizenship of the child followed that of the parent, was the true rule of international law. Yeah, laurels. Yeah, exactly. Yeah, 100%. As now recognized in the most civilized countries and supersede the rule of the common law depended on birth within the realm originally founded on feudal constitutions. But by the time of the adoption of the Constitution of the United States in 1789, and long before, it would seem to have been the rule in Europe generally, as certainly was in France, as said by Pother, citizens, true and native-born citizens, are those born within the extent of the dominion of France. And mere birth within the realm gives the rights of natural-born citizens, independent of the origins of the father or mother and their domicile. I'm understanding that's not the law of France today. And children born in a foreign country of a French father who would not establish his domicile there were not given up his intention of returning, were also deemed Frenchmen, as he said, by favor of a sort of fiction. Now, it's interesting if this turns on this concept of domicile, because that could be interesting, this concept of domicile for illegal immigrants, because anyone here under temporary visa would not be said to be domiciled within the United States. That would be a very strange idea if they were, right? So domicile is, okay. Domicile is different than residence. You can have multiple residents. You can only have one domicile. Domicile is established somewhere, and then domicile only changes by express act and is not determined strictly by time. So like if you're moving from one state to another, right? Like I live in Texas, or I used to live in Virginia. I was domiciled in Virginia, right? Because I lived in Virginia. And then I moved to Texas. So you could ask the question, did I become domiciled in Texas? And domicile is determined basically by, long story short, by the intent to establish domicile as a place of permanent, as a place to which your place of permanent establishment. And you can only have one of them. And it is not established merely by time. So like if I went to go work in like New York City for even extended periods of time, even like for years, right? It doesn't necessarily mean I'm domiciled there. Like that's the distinction between like residency and domicile. But, you know, I got my voter, I vote in Texas. I'm registered to vote here, you know, like my address is here. I don't have any intention to ever return to Virginia. So my domicile is pretty clearly established in Texas, right? And by the same extension, inside the United States. And this would incidentally apply if I worked overseas, right? I could work overseas for years and years and years and not consider myself domiciled there within the meaning of this concept, right? Because you can only have one domicile. There can be only one. So it would be very difficult to say that a person who is visiting here on a temporary visa was domiciled in the United States, even if they were here on a long-term visa, right? That'd be a very weird concept. It's like, yeah, you're not domiciled here. So merely visiting here wouldn't be domicile. Merely a work visa would not be domicile, right? Because I would be like, that doesn't make any sense. Even if it went on for years, it wouldn't be domicile. So if this turns on the concept of domicile, that's an interesting concept. And then of course, like, well, an illegal immigrant, when they first cross the border, is not domiciled in the United States, because again, domicile requires a little bit more than that. So if the idea is you're never domiciled in the United States, then that's an interesting way of doing this. Yeah. It's an area of law that hasn't really been explored before. It's been explored a little bit in the context of domicile within states. The most frequent way for it to pop up would be in the event of dying without a will. Would be the most frequent way for it to pop up in the United States concept. It won't pop up very often. Even if you die without a will, it won't pop very often. It's relatively rare. I said the most frequent way. I said the most frequent way, which isn't to say it's frequent. It's just the most frequent way, but it's still pretty rare. But like, if I died without a will, we need to know under what state law to like, you know, deal with my estate, right? So it's like, which state law applies to my estate? And the answer to that question is my state of domicile. So, you know, if I were moving across the country and if I were rich so that it mattered, right? If I were traveling from Virginia to Texas, you know, like, and I die along the way kind of thing, right? It's like, at what point does my domicile become domicile? And you could have a fight over it. So there is some law dealing with this concept. Most often in this concept, but there is some law dealing with this concept. But yeah, it's interesting concept. Yeah. Didn't Amber Heard try to quickly change her domicile after civil case verdict? She sure did. She 100% did try to change her domicile for certain avoidance issues. You're 100% correct. Yeah. You're thinking about the man without a home country got stuck in the airport. Yeah, that's a sad story. That was unfortunate because his home country ceased to exist. And now he's like without a country, and that's just rough. By the time of adoption of the Constitution of the United States and long before, it would seem to be the rule that, okay, we read that part. Where were we? The general principle of citizenship by birth within French territory prevailed until after the French Revolution, and was affirmed in successive constitutions by the one adopted by the Constituent Assembly in 1791 to that of the French Republic in 1799. The Code of Napoleon changed the law of France and adopted, instead of the rule of the country of birth, jus soli, the rule of descent of blood, jus sanguinis. Blood and soil, man. Blood and soil. Lol. But an eminent commentator has observed that the framers of the code appear not to have wholly freed themselves from the ancient rule of France, or rather, indeed, ancient rule of Europe, accordingly to which nationality has always been in former times determined by the place of birth. So France apparently changed it in 1807. Napoleon apparently changed it in 1807. What a prick. What a prick. Also, it's French. So, you know. We aren't French, though. Well, maybe Louisiana is, but, you know, we'll deal with that another time. Louisiana always fucking everything up. Louisiana, why can't you just be a state like normal states? Why do you have to be French? God damn it, Louisiana. The later modifications of the rule of Europe rest upon the constitution or laws or ordinances of various countries and have no import bearing upon the interpretation and effect of the Constitution of the United States. The English Naturalization Act and the Commissioner's Report of 1869, out of which it grew, both bear the date since the adoption of the 14th Amendment of the Constitution, and observed by Mr. Dicey, the act has not affected the principle by which any person who, whatever the nationality of his parents, is born within the British Dominion, acquires British nationality at birth, and is natural born subject. At the time of the passage of the act, although the tendency of the continent on Europe was to make parentage rather than birthplace the criterion of nationality and citizenship was denied to the native-born children of foreign parents in Germany, Switzerland, Sweden, and Norway, yet it appears to have been conferred upon such children in Holland, Denmark, and Portugal, and when claimed under certain specified conditions in France, Belgium, Spain, Italy, Greece, and Russia. There is therefore little ground for the theory that at the time of the adoption of the 14th Amendment of the Constitution, there was any settled and defined rule of international law generally recognized by civilized nations inconsistent with the ancient civilization by birth within the Dominion. Yeah, a constitutional amendment cannot be unconstitutional. That doesn't make sense. It wasn't ratified correctly. You do realize if the 14th Amendment was not ratified correctly, that would lead to all kinds of problems, right? That would undo a lot of stuff if the 14th Amendment was not ratified correctly. Yeah, I don't think you want to go there. Nor can it be doubted that the inherent right of every independent nation for determining itself, and according to its own constitution and laws, what class of person shall be entitled to citizenship. Isn't anyone without diplomatic immunity subject to state and federal jurisdiction? If not, how can you prosecute an illegal alien for things like theft? That's a really good question. I've been asking that question a lot, Russ. You think the text was wrong about Denmark? Probably not historically. I'm sure it's wrong about Denmark today. President Trump is currently answering press questions. I'm watching him in the background. He's giving a press conference about something. I think he's talking about infrastructure. So a lot of this opinion reads like bad law office history. Nah. Yeah, this 14th Amendment not ratified correctly, by the way, is some bullshit. This is some sovereign citizen bullshit. Don't go into the rabbit hole. Don't go into the rabbit hole. This is some sovereign citizen bullshit. You don't want to go down that road. Okay? It has a lot to do with whether or not Ohio was a state or not, and some other bullshit that you really don't want to learn more about. Okay? The only reason that people debate this is because the sovereign citizens are like, I'm not a citizen of the United States because the 14th Amendment wasn't ratified because Ohio wasn't really a state, and some other bullshit. Okay? Don't go down this road. There is nothing to be gained by going down this road. You're entering a world of pain. Leave it alone. Save your sanity. Both in England and the United States, indeed, states have been passed at various times enacting that certain issues born abroad by English subjects or American citizens, respectively, should inherit, at least to some extent, the right of their parents. But those statutes applied only in cases coming within their purport, and has never been considered in either country as affecting the citizenship of persons born within the Dominion. The earliest statute was passed by the reign of Edward III. In the Rolls of Parliament, it's stated that before these times there have been great doubts and difficulty among the lords of the realm and the commons, as well as men of the laws of others, whether children who are born in parts beyond the sea ought to bear the inheritance after the death of their ancestors in England, because no certain law there has been there unattained. And by kings, lords, and commons who unanimously agreed there was no matter of doubt that the children of our Lord and King, whether they are born on this side of the sea or beyond the sea, should bear the inheritance of their ancestors. In regards to other children, it was agreed that Parliament, they should also inherit whatever they might be born in service of the king, because the Parliament was about to depart, and in business demanded great advisement, and good deliberation how it should be best and most surely done. By making the statute, it was put off to next Parliament. By reason, apparently, of prevalence of the plague of England, no act on subject was passed until 1350, when the Parliament passed an act entitled A Statute for Those Who Are Born in Parts Beyond the Sea, which, after reciting that some people be in doubt if children born in parts beyond the sea, out of the legions of, is it lige or legions, you think? Out of the legions of Americans, should be able to determine that any inheritance within the same legions or not, whereof a petition was put in Parliament, and was not that after that same wholly assented. It was agreed and affirmed that the law of the Crown of England is, and always has been, that children of the King of England, in whatsoever parts they be born, in England or elsewhere, be able and ought to bear inheritance after the death of their ancestors. And also agreed that certain persons named, which were born beyond the sea, out of the legions of England, shall be henceforth be able to enjoy their inheritance after the death of their ancestors, in all parts within the legions of England, as well as those that should be born within the same legions. And further agreed that all children inheritors from which henceforth shall be born without legions of the king, whose fathers and mothers at the time of their birth shall be at the faith and legions of the King of England, shall have and enjoy the same benefits and advantages advantages to have and bear the inheritance within the same legions, to others have foresaid in times to come. So always the mothers of said children do pass the sea by legions and wills of their husbands. Exciting. It has sometimes been suggested that this general provision of statutes was a declaration of common law. But all suggestions to that fact seem to have been derived immediately or ultimately from one or the other of these two sources. The one being the year of the book in 1483. You got to love these old citations, right? It's like you just absolutely have got to love, man, that we're trying to determine who someone as a citizen are. And you got to love these citations to like the 15th century, 14th century, 13th century. It's like, you've got to love this, like, let me tell you about the law for the last 800 years. This is some, this is you got to love this deep shit, right? You got to love this deep shit, man. This is good shit. Pump it into my veins. I don't need to do cocaine. I've got decisions from 1483, man. Great. Hey, buddy. Hey, buddy. I really need a hit, man. I really need a hit. I'm having a tough day, man. I really need a hit. You got any of that 1400s case law, baby? You know how I like it. You know. Oh, man. Let's just skip to the next paragraph. The statute of 25 Edward III recites the existence of doubts as to the right of foreign-born children to inherit in England. And whilst the Declaration of Rights of the King, and retrospective as to all persons specifically named, yet as to all others it is in terms merely prospective, applying to those who shall be born henceforth. Mr. Benny, in his paper above cited, after critical examination of the statute and of the early king cited, concluded, there's nothing in the statute which would justify the conclusion that its declaration of the common law in any but a single particularity, namely in regard to children of the king, nor has at any time been judicially held so. The notion that there's any common law principle to naturalize the children born in foreign countries of native-born American father or mother must be discarded. There is not and never was any such common law children. If they're not being naturalized, they must be natural born, right? Because they don't have to be naturalized if they're natural. I can read the yearbooks on Professor Seep's database at Boston U Law School. Nice. Was I trying to do Chappelle's meme? It wasn't really what came to mind, but now that you pointed out, that was, I guess, Chappelle. So it was more subconscious Chappelle, but it was just a funny gag that Uncivil wanted to do. Just a little funny gag. I get it straight from my dealer, baby. Yeah. I get it straight from my dealer. I do coke, baby. Lord Coke. Yeah. An act for the naturalization of children of His Majesty's subjects born in foreign countries during the late troubles. All persons who at any time were born out of His Majesty's dominion, whose fathers or mothers were natural-born subjects of the realm, were declared to be natural-born subjects. By the statute of 7 Anne, 1708, The children of all natural-born subjects born out of the allegiance of Her Majesty, her successor, $2 from Tracy Fang. All this to tell us if Arc is a citizen, you know it, baby. You know it, baby. All this to tell you if Arc is a citizen. Yeah, we got to go through a couple hundred years of common law to figure out whether or not he's a citizen or not. It's great. It's great. Thank you for the super chat. Moreover, under some statutes, as stated in the report of 1869 in the Commissions for Inquiry into the Laws of Naturalization and Allegiance, no attempt has ever been made on the part of the British government, unless in Eastern countries where the special jurisdiction is conceded by treaty. Lol. Yeah, there's a lot they're burying in that sentence, right? There's a lot they're burying in that sentence. Special jurisdiction in Eastern countries conceded by treaty. What British history might we be contemplating there? To enforce claims upon or asserted rights in respect of persons born abroad as against the country of their birth whilst they were resided therein, and when the law is invested within its nationality. In appendix to their reports are collected many such cases, which the British government declined to interpose, the reasons being most clearly brought out of its dispatch by Lord Malmesbury. That can't be a guy's real name. Malmesbury. What kind of name is Lord Malmesbury? That can't be a person's name. That's made up. The Foreign Secretary? The British named their Secretary of State, and the guy's name was Lord Malmesbury, and I'm supposed to take this guy seriously? You can't, okay. To the British ambassador at Paris saying, it's competent for any country to confer by general or special legislation the privileges of nationality upon those who are born out of its own territory. But it cannot confer such privileges upon such persons as against the country of their birth, when they voluntarily return to and reside therein. Those born in the territory of a nation are, as a general principle, liable when actually they are into the obligation incident to their status of birth. Great Britain considers and treats such persons as natural-born subjects and therefore cannot deny the right of other nations to do the same. But Great Britain cannot permit the nationality of children of foreign parents born within their territory to be questioned. By the Constitution of the United States, Congress was empowered to establish a uniform rule of naturalization. In the exercise of this power, Congress, by successive acts, beginning with an act entitled An Act to Establish a Uniform Rule of Naturalization, passed at the second session of the first Congress under the Constitution, has made provision for the admission of citizenship of three principal classes of persons. First, aliens having resided for a certain time within the limits and under the jurisdiction of the United States, and naturalized individually by proceeding in court of record. Second, children of persons so naturalized, dwelling within the United States and being under the age of 21 years at the time of naturalization. Third, foreign-born children of American citizens coming within the definition prescribed by Congress. In an act of 1790, the provision as to foreign-born children of American citizens were as follows. Well, we can kind of skip that. The children of citizens of the United States that have been born beyond sea or outside the limits of the United States shall be considered as natural born, provided that the right of citizenship shall not descend to persons whose fathers have never been resident in the United States. Kurt is 100% nerding out. It's 100%. Shrewsbury is a town in Pennsylvania. That sounds less ridiculous, though, than whatever fucking name that was, that bullshit. Marsbury or Marsbury. Shrewsbury sounds reasonable by comparison, man. Isn't a shrew like a kind of like animal, like a ferret or something? Isn't that like what a shrew is? Okay, I mean, yeah, right. Pretty sure it's like a mole. Yeah. It's ferret mole adjacent, right? something in that neighborhood. In 1802, are members for chats invisible or are you blocked? Your chats are invisible. I cannot see you. The provisions of the acts concerning the children of persons duly naturalized under laws of the United States not being restricted to the children of persons already naturalized might well be held to include children of persons thereafter naturalized. But the provision concerning foreign-born children being expressly limited to children of persons who were then or had been citizens clearly did not include foreign-born children of any person who became a citizen since its enactment. Right. Like, the children don't become citizens just because their parents become citizens. That would be weird. That is not the law. Mr. Binney's paper, as he states in his preface, was printed by him in the hope Congress might supply this deficit in our law. In accordance with his suggestions, was enacted by the statute of February the 10th of 1855 that persons heretofore born or hereto born outside the limits and jurisdiction out of the United States, whose fathers were or shall be at the time of their birth citizens of the United States, shall be deemed and considered and hereby declared to be citizens of the United States, provided, however, the rights of citizenship shall not descend to persons whose fathers never resided in the United States. So fathers get shafted, man. Fathers get shafted in U.S. law once again. Man, it's bullshit. Right? Mothers don't have this problem, but fathers, if they never lived here, man, their children don't become citizens just because, even if they're citizens. So you have to live in the United States at least a little bit. If you never live in the United States, your children don't become citizens. But that isn't true of mothers. It's sex discrimination, and it's wrong. It's some bullshit. Fathers getting shafted. It thus clearly appears during the half-century intervening between 1802 and 1855, there is no legislation whatever for citizenship of children born abroad during that period of American parents who had not become citizens of the United States before the Act of 1802. And the Act of 1855, like every other act of Congress has on the subject, has, by express proviso, restricted the right of citizenship thereafter conferred upon foreign-born children of the United States to those children themselves unless they become residents of the United States. Oh, Lord have mercy. Here is nothing to countenance the theory that the general rule of citizenship by blood or descent has displaced in this country the fundamental rule of citizenship by birth within the sovereignty. You always know who the mother is? Fathers can be unclear? Why would it be unclear? Just ask the mother. She'd never lie. Passing by questions once earnestly controverted, but finally put out to rest the 14th Amendment of the Constitution, it is beyond doubt that before the enactment of the Civil Rights Act of 1866 or the adoption of the Constitutional Amendment, all white persons, at least born within the sovereignty of the United States, whether children of citizens or foreigners, excepting only children of ambassadors or public ministers of foreign government, were native-born citizens of the United States. Incidentally, by the way, we did actually read a case a while back where a girl got screwed on this. Well, I don't know if she necessarily got screwed, but it was like, she was like, all of her siblings were U.S. citizens, but she wasn't. And I don't quite remember how her siblings became American citizens, but she didn't, because she was a child of a foreign ambassador. And we actually read a case in which her citizenship was stripped because America said, oh, you were never a citizen in the first place. And she sued. And they're like, well, all your sisters are, but not you. Like, all of them are American citizens, but not you because you're an ambassador's kid. That was rough, man. That was rough. I'm like, you're born in the United States. You had an American passport. And at some point, America apparently figured it out and stripped it right out of her. Stripped it right out. That's rough, man. That's a rough go. Yes, all white persons. In the enactment of the Civil Rights Act of 1866. Yeah. I mean, Yeah. I don't know how much you know about American history, but yeah. We got better. All white persons at least born within the sovereignty of the United States, whether children or citizens of foreigners, excepting only children of ambassadors or public ministers of foreign government, were native-born citizens of the United States. Yeah, I liked it when France passed a law that made DNA checking your children illegal. That was like the ultimate. That was one of those like really big red pill moments. It's like when DNA testing started becoming like popular, France passed a law to make it illegal to DNA test your children. They were concerned that too many families might break up. Yeah. 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 In the forefront, both of the foreign 14. How okay, you've got to help me, Chuck M. You've got to help me. How did anything I say state or imply that I personally was anti-paternity testing? How did anything I say state or imply I personally am anti-paternity testing? How the hell are you getting that conclusion from anything I said? This is what I want to know. Why would a mom lie? And you didn't understand it was a joke? Is that it really? Is that what is that the thing? Like you didn't understand that was a joke? With my absolute deadpan delivery, staring directly into camera for a somewhat lengthy period of time, where I just deadpan stared into the camera for like 5 full seconds. It wasn't clear it was a joke. Jesus Christ, man. Jesus Christ. Okay, pressing on. In the forefront, both of the 14th Amendment of the Constitution and the Civil Rights Act of 1866, the fundamental principle of citizenship by birth within Dominion was reaffirmed in the most explicit and comprehensive terms. The Civil Rights Act, passed at the first session of the 39th Congress, began by enacting I told a really good joke the other day. I told a really good joke, and I didn't get enough love. I didn't get enough love. So I'm going to tell you my joke, and then you can laugh at my joke, okay? We were discussing TikTok on Sean's stream, potentially criminal. We were discussing TikTok, and we were reviewing a TikTok, or an apparent TikTok, I suppose. We were reviewing an apparent TikTok that appeared to be taken by an active military Air Force pilot, a woman in this particular case, who was filming the interior of the plane, when it appeared to be doing like mission stuff. Like, it's an Air Force plane that's flying. So, kind of implies that, it's, being directed by the Air Force. And she's filming the interior of the plane, okay? And so I say to him, like, what's the probability? Like, what is the probability that something she's filming is classified? Because, what is the probability that it's classified? And then I said, okay. Then we were talking about something else for a while. And I was like, here was what I said. I said, I'd like to tell that military member a riddle. What is another name for the king's closest advisor's leader? What is another name for the king's closest advisor's leader? A court-martial. But not Dutch. Yeah, okay. That's the joke. You may now laugh. I'm going to pull a Jed. I'm going to pull a Jed. Please clap. Please clap. That same Congress shortly afterward, evidently thinking it unwise and perhaps unsafe to leave so important a declaration of rights to depend upon ordinary act of legislation, which might be repealed by any subsequent Congress, framed the 14th Amendment, and by joint resolution proposed it to the legislature. And the Secretary of State issued a proclamation showing it to have been ratified by the legislature of the requisite number of states. The first section of the 14th Amendment of the Constitution begins with the words, all persons born or naturalized in the United States are subject to the jurisdiction thereof, are citizens of the United States and of the state from which they reside. And it appears upon the face of the amendment, as well as from the history of the times, that it was not intended to impose any new restrictions upon citizenship, or prevent any person from becoming citizens by fact of birth within the United States, which should therefore become citizens. I have to say, on a personal level, because I want to celebrate when I'm happy, right? I talk about depression on channel. I talk about it from time to time. And I'd also like to talk about it when I'm happy. And I have to say that these random jokes and these random asides that we've been doing, I've been very happy. I'm just happy that we're happy. We're having fun together. The chat's having fun. I'm telling some stupid jokes. You're pretending to laugh at my stupid jokes. And this is making me happy. So I just want to say that I'm in a relatively positive spirits. And it is at least partially because of you guys that I'm feeling relatively positive. It probably also doesn't hurt that, President Trump is now in office and I'm still, drinking the sweet milk of that, celebration, and will be for probably some time. But, your guys are also helping. So I just want to say that you guys are awesome. Its main purpose, doubtless, has often been recognized by this court to establish the citizenship of free Negroes, which has been denied in the opinion of the Chief Justice Taney. Lame. And to put it beyond doubt that all blacks, as well as whites born or naturalized within the jurisdiction of the United States, are citizens of the United States, citing the Slaughterhouse cases. Okay, the Slaughterhouse cases was 1873. So it had been decided at this point in time. But the opening words, all persons born, are general, not to say universal, restricted only by place and jurisdiction, and not by color or race. It was clearly recognized in all the opinions delivered in the Slaughterhouse cases. It's been a long time since I've read the Slaughterhouse cases, but I don't remember the Slaughterhouse cases really having much to do with any of those things. But okay. In those cases, the point adjudicated was the statute of Louisiana, granting to a particular corporation the exclusive right for 25 years to have and maintain slaughterhouses within a certain district, including the city of New Orleans. Yeah, I mean, it was a case literally about slaughterhouses. That's why it's called the Slaughterhouse cases. Did you know that? Did you know that? The Slaughterhouse cases were about slaughterhouses. Wow. I mean, yes, that's true. requiring all cattle intended for sale or slaughter in that district to be brought to the yards and slaughterhouses of the grantee, authorizing all butchers to slaughter their cattle there, and empowering the grantee to exact a reasonable fee for each animal slaughtered, which was within the police power of the state, which is the general power to do stuff. Remember, police power doesn't mean police like white, blue, and red lights. It means the general power to do stuff, the general power to make you the state's bitch. And not conflict with the 13th Amendment of the Constitution as creating an involuntary servitude, nor 14th Amendment as abridging the privileges or immunities of citizens of the United States. Yeah, that's what I'm going to say from now on. When that's an easier way to describe it. That's an easier way to describe what police power is, right? I normally say it's the general power to do stuff. What I should just simply say is police power is the power of the government to make you its bitch. That's more accurate and more descriptive and more memorable. Duncan, Idaho, for $5 says, so far as the Supreme Court's ability to clarify the 14th Amendment to not include children of illegals by default, you're saying there's a chance? We're thinking. We're collectively thinking, you and I together in tandem. I mean, the state could at least buy me dinner first. Damn. Or depriving persons of their liberty or property without due process of law, or denying them their equal protection of laws. Mr. Justice Miller, delivering the opinion of the majority of the court after observing the 13th, 14th, and 15th Articles of Amendment. Who calls them Articles of Amendment? How old is this language? You know, how old is this language where we're calling them Articles of Amendment? You know, this is some old school shit. It's like court cases that call like constitutional amendments by their like original numbering, just to really confuse the shit out of you. So the First Amendment isn't the First Amendment, it's the third article of amendment in the Bill of Rights. And like in some old school cases, you'll see that shit. And then you have to remember which one they're talking about because they use the original numbering. And it'll just confuse the living shit out of you when you're like reading like 150-year-old cases. What was the first and second article of the Constitution? Well, I'm so glad you asked. The second article of the Constitution is better now known as the 27th Amendment to the Constitution. It took a while to get ratified. The second article of the Constitution was the one that says Congress shall not increase its own pay in its own term, which is now the 27th Amendment to the Constitution. The First Amendment of the Constitution would have changed the representation in Congress in a way that would have no impact today. It's irrelevant. It would have changed the size of the House in a way that would have like had no impact today. It's just like it just changes the numbers in a way that like it's like it changes the bounds, but it's kind of dumb. Yes. YE is the. It's Thune. Yes. YE is for the Y looking T. Yeah, that's not ye, it's the. Yeah, because it's TH, because it's Thune. Old letters. Old letter hype. Old letter hype. Of course, the Constitution does set the maximum size of Congress. Did anyone know that? It's one of the more obscure provisions of the Constitution. But it says the maximum size of Congress, there can't be more than I think it's one congressman per, And if I get this number right off of memory, I'll be impressed. But I think it's 1 out of 30,000. So there's a maximum size of the house. So we're not allowed to have we couldn't have a house that had more than 15,000 members in it. That's as big as we're allowed to go. No more than 15,000. Yeah, Lord. Imagine a building that could handle 15,000 people at once. You mean like a stadium? I know some buildings that can handle 100,000 people at once, or even a little bit more than that. I know some buildings that can handle 120,000 people at once. It'll be great, man. Yeah, like a hockey arena. Yeah, like the arena they met in yesterday. That holds 20,000 people. The Caps Stadium, that holds about 20,000 people. Yeah, no problem. Imagine them in a sports stadium. It'd be great. It'd be great. We can have voting devices on each chair. It'll be fucking fantastic. Mr. Justice Field, in a dissenting opinion, which Chief Justice Chase and Justice Swain and Bradley concurred, said at the same time, it recognizes in express terms it does not create citizens of the United States and makes their citizenship dependent upon their place of birth or the fact of their adoption is not upon the constitutional laws of any state or condition of their ancestry. Mr. Justice Bradley also said the question is now settled by the 14th Amendment itself, that citizenship of the United States is the primary citizenship in this country. Well, I'm not necessarily sure that's exactly what the 14th Amendment says, but fine. And the state citizenship is secondary and derivative, depending upon the citizenship of the United States and the citizen's place of residence. The states have not now, if they ever have, the power to restrict their citizenship to any class of persons. And Mr. Justice Swain added, the language employed is unqualified in the scope. There is no exception in its terms, and can be properly none in their application. By the language, citizens of the United States was meant all such citizens, and by any person was meant all persons within the jurisdiction of the state. No distinction is intimidated on account of race or color. This court has no authority to interpolate a limitation that's neither expressed nor implied. That language that's not particularly helpful. Our duty is to execute the law, not to make it. The provision provided was not intended to be confined to those of any particular race or class, but to embrace all races, classes, and conditions of men. Women also optional. This part is false per the 14th Amendment sponsor. Again, what language are you referring to? Are you bringing this up in, what language are you referring to where you say the author doesn't say this? Or what are you saying by this? What language, by what author are you saying? The sponsor of the bill. Yeah, okay, but when did they say that or where? Can you give me a citation or something? Could you tell me where he said that? Could you put it in Discord? That'd be nice. And so we can look at that. That'd be interesting. I'd be interested to see what they had to say. This amendment, which I have offered, is simple declaratory of regard, as the law has already stated, that every person born within the limits of the United States and subject to their belong to the families of ambassadors of foreign ministries to the government of the United States, but will include every class of people. That I don't think helps you, to be honest, but okay. I don't see how that language helps you. That seems to be the same language we've been reading already. Foreigners, aliens. You didn't, in your quote, there's no foreigners or aliens anywhere in your quotes. So you gave me a incomplete quote then. All right, where were we? See the second post. I did. Everything it says this amendment, which I have offered, is simple. Oh, maybe I don't need top chat. Maybe I need something else. Maybe it's my fault. Oh, it is my fault. It was filtered out by not being top chat. I apologize. That's my fault. This amendment, which I have offered, is simple declaratory of what I've regarded as the law of the land already, that every person born within the limits of the United States and subject to their jurisdiction is by virtue of natural law and natural law citizens of the United States. This will not, of course, include persons born in the United States who are foreigners, aliens who belong to families of ambassadors. Okay, I mean, that's something. That's something. I give you points. That's something. Fair enough. I was eating a drumstick. That sounds nice. Chicken sounds nice. I think we need. Yeah. In weighing a remark uttered under such circumstances, well to bear in mind the often quoted words of Chief Justice Marshall. It's a maxim not to be disregarded that general expressions in every opinion are to be taken in connection with the case in which those expressions are used. If they go beyond the case, that may be respected, but ought not to control the judgment in subsequent suit when the very point is present for decision. The reason of this maxim is obvious. The question actually before the court is investigated with care and considered to its full extent. Other principles which may serve to illustrate it are considered in their relation upon the case decided, but their possible bearing on all their cases is seldom completely investigated. That neither Justice Miller nor any other justices who took part in the decision of Slaughterhouse understood the court to commit to the view that all children born in the United States of citizens or subject to foreign states were excluded from the operation of the first sentence of the 14th Amendment is manifest from a unanimous judgment of the court delivered but 2 years later, which all those justices but Chief Justice Chase were still on the bench, in which Chief Justice Waite said, allegiance and protection are, in this connection, reciprocal organizations. Allegiance and protection are reciprocal. That's interesting language, that potentially for the birthright citizenship potential. There's some quotes here that you could potentially use for the idea. I'm seeing the making of like at least part of a brief that would make sense. I skipped a really important paragraph. I've been trying to read every paragraph. Sometimes I skip it if I lose my place, but I'm not going back and rereading it. I've read 31 pages. Okay. I've read 31 pages. Okay, if I skipped a paragraph because I lost my place and I went to the next paragraph, which I've done like a couple times, dude, I've read 31 pages. Okay, I'm sorry I skipped your favorite paragraph. Give me a fucking break, man. Jesus Christ. I am not getting any respect. I ain't got no respect. They were natives or natural born citizens as distinguished from aliens or foreigners. Okay, this one's pretty good. At common law, within the nomenclature of which the framers of the Constitution were familiar, it was never doubted that all children born in a country of parents who were citizens became themselves upon their birth citizens also. These were natives or natural born citizens as distinguished from aliens or foreigners. Well, that's pretty good. That's helpful language. What the fuck? Some authorities go further and include citizens of children born within the jurisdiction without reference to citizens of their parents. As to this class, there's been doubts, but never as to the first. For the purposes of this case, it's not necessary to solve these doubts. It's sufficient for everything we have said now that all children born of citizen parents within the jurisdiction are citizens. The decision in that case was a woman born of citizen parents within the United States was a citizen, although not entitled to vote, the right to the elective franchise not being essential to citizenship, lol, because, women didn't have the vote yet. The only adjudication that's been made by this court upon the meaning of the clause and subject to the jurisdiction thereof is the leading provision of the 14th Amendment, Elk versus Wilkins, in which it was decided that an Indian-born member of one of the Indian tribes within the United States, which still existed and was recognized as an Indian tribe by the United States, who had voluntarily separated himself from his tribe and taken upon his residence among the white citizens of the state, but did not appear to have been naturalized or taxed or in any way recognized or treated as a citizen, either by the United States or by the state, was not a citizen of the United States as a person born in the United States and subject to the jurisdiction thereof with meaning of the clause in question. That decision was placed upon the grounds that the meaning of the words not merely subject in some respect or degree to the jurisdiction of the United States. Okay, so this is a helpful language for the birthright citizenship people. When they talk about jurisdiction, like this is some helpful language here. So the people who want President Trump's EO to work, you can pay attention. This is some helpful language for you. That decision was, you do have to cite the provision that says that Native Americans aren't citizens to get what you want, but as long as you're there, to your benefit, it's like Native Americans don't even qualify as citizens within the meaning of the 14th Amendment. So how can these people who are here illegally, if Native Americans don't qualify as citizens, right? So as long as you're comfortable citing that proposition, you got something that can work for you. So you can go down that road if you want to give that a shot. That decisions were placed upon the grounds that meaning of the words not merely subject in some respect or degree to the jurisdiction of the United States, but completely subject to the political jurisdiction and owing them direct and immediate allegiance, and that by the Constitution as originally established, Indians not taxed were excluded from persons according to whom numbers represented in Congress and direct taxes were apportioned among the several states, and Congress was empowered to regulate commerce not only with foreign nations and among the several states, but with Indian tribes. That the Indian tribes, being within the territorial limits of the United States, were not strictly speaking foreign states, but were alien nations. Yeah, so they're domestic nations. It's a very weird concept, but yeah. But were alien nations, distinct political communities, the members of which owed immediate allegiance to their several tribes and were not part of the people of the United States, that the alien and dependent condition of their members to one of those tribes could not be put off at their own will without the assent, action, or assent of the United States, and that they were never deemed citizens except when naturalized, collectively or individually, under explicit provision of treaty or of an act of Congress, and therefore Indians born within the territorial limits of the United States, members of and owing immediate allegiance to one of the Indian tribes, an alien, though dependent power, a dependent nation, although in a geographical sense born in the United States, are no more born in the United States and subject to the jurisdiction thereof, within the meaning of the first section of the 14th Amendment, than the children of subjects of any foreign government born within the domain of that government, or children born in the United States of ambassadors or other public ministers. So you got some language there that, might be able to help you guys if you're interested in that kind of thing. It was observed that the language used in citizenship in the first section of the Civil Rights Act by the very Congress which framed the amendment were all persons born in the United States and not subject to the foreign power, excluding Indians not taxed. How many people are watching the stream, incidentally? Is anyone watching it? Have I been talking? 379 people. That's actually not bad for pretty geeky con law stuff. That's pretty good. That's pretty good for geeky. We peaked out at like 400 something, it looks like. I guess we lost some people. Mr. Justice Harlan and Mr. Justice Woods, dissenting, were of the opinion that Indians in question, having severed himself from his tribe and becoming a bona fide resident of the state, have therefore become subject to the jurisdiction of the United States within the meaning of the 14th Amendment. And in reference to the Civil Rights Act of 1866 said, beyond question that by act, national citizenship was conferred directly upon persons in this country of whatever race, excluding only Indians not taxed, who were born within the territorial limits of the United States and were not subject to any foreign power. And that view was supported by reference to the debates in the Senate that upon the act and to the ineffectual veto thereof by President Johnson, to which he said, by the first section of this bill, all persons born in the United States and not subject to any foreign policy, excluding Indians not taxed, are declared to be citizens of the United States. This provision comprehends the Chinese of the Pacific states, Indians subject to taxation, the people called gypsies, as well as the entire race designated as blacks, persons of color, Negroes, mulattoes, and persons of African blood. This is in a bill. This isn't a bill. We're using these as legal terms. Wow, you gotta love this language, man. This is some old school language. Holy shit! Like, it's like jam. Like in the old language is like hardcore, right? Gypsies, mulattoes. Holy shit! Every individual of those races born in the United States is made a citizen of the United States. Well, that's nice. The decision in Elk versus Wilkins concerned only members of the Indian tribes within the United States and had no tendency to deny citizenship to children born in the United States of foreign powers of Caucasian, African, or Mongolian descent, not those in diplomatic service to a foreign country. Look at the old language of what they used to call special needs. Yeah, well, the interesting thing with that is like the euphemism treadmill, which I'm sure some of you are familiar with the concept of the euphemism treadmill. Because the language of like special needs, like you start off with some language and then you use a term that's like meant to be like kinder, and then that language itself becomes offensive and you have to find alternative language. So like the evolution of language through the euphemism treadmill is an interesting concept. We let gypsies be citizens? We did. Gypsies, tramps, and thieves can all be citizens of the United States. I learned that from learned Justice Scher. The real object of the 14th Amendment of the Constitution, qualifying words, all persons born in the United States by addition and subject to the jurisdiction thereof, would appear to exclude by fewest and fittest words, besides children of members of the Indian tribe, standing in peculiar relationship to the national government, unknown to common law, the two classes of cases, children born of alien enemies in a hostile occupation and children of diplomatic representatives of a foreign state, both of which have already been shown by law of England and our own law from time of the first settlement, have been recognized exceptions to the fundamental rule of citizenship by birth within the country. The principles upon which each of these exceptions rests were long ago distinctly stated by the court. How many more pages of this do I have to read? I'm on page 35. I'm kind of tired. How long is this opinion? Holy shit. I mean, it's 84 pages. Is it all opinion? Jesus Christ. I'm going to have to call it because I'm tired and I've run out of saliva. There it is. Damn. It ends on page 57. I don't know that I have 22 more pages in me, guys. It's like almost as much as I've read already. Yeah, so I think I'm going to have to conclude. 2 hours, I think 2 hours is the limit. Just go back to the holding. Okay. You got to pace yourself, man. Has this colored my opinion of Trump's EO? There's some language here that you might be able to get to where Trump's trying to be. But I don't know. Yeah, the holding is the arc as a citizen. I mean, we sort of acquired that. Yeah, it talks about permanent domicile. So the best argument, I think, the best argument for Trump's EO is probably, well, my first thought at least, right? My first thought is the best argument for Trump's EO is rooted in the concept of domicile. And we're not allowing them to become domiciled here because it's a violation of our law. So yeah. So I think that's going to conclude our stream. The idea that children of illegals are citizens coming from a 1980 footnote. How can you join Discord? All links are on our link tree. So type exclamation link tree and it should give you a link for Discord and everything else. Yeah, I think I'm going to go ahead and sign off for now. It's just been interesting, though. It's definitely going to be fought over a lot. It's going to be fought over a lot. And, yeah. Was the question about illegals giving birth here to gain a football to ever address? No. And also, of course, like at this time, America had no welfare state. So, like, there would be no reason to do that in American history. The creation of the welfare state has been obviously a major issue here. Yeah. I'm a little tired. I'm gonna have to cut up some 14th century decisions and freebase it or something. I don't know. Yeah, I'm gonna sign off for now though. I'm tired. What would be like the equivalent of taking uppers and downers in this analogy? Like, yeah, I'm gonna take some 14th century case law. And I'm gonna mix it with a little sovereign citizen and see what happens. Maybe taking like some bad case law. It's like I'm gonna take some Brandenburg, and I'm gonna mix it up with a little bit of Shank, so I get my stimulant depressant quota correct. Yeah. Oh Lord, fun times. Speedballing the law. Yeah, exactly. All right, I'm gonna sign off for now, guys. You guys are fun. I love you guys. Oh, who can I Who can I send you over to? Who's streaming? Who's streaming so I can dump you on someone's page and be a good streamer? Who's streaming? You guys want to go over to Robert Guvera? He's cool. I'll dump you over to Robert Guvera. He's fun. Be nice. You know the drill. I'll see you later. Love you guys. Bye.